We work wherever possible with government, but there are lines that can never be crossed. There are issues which we must, at all costs, defend. We do that through a number of channels. And as I said, we are an inherently political organisation. We're independent, we're non-partisan. We speak for the legal profession, but also for the rule of law. And those channels are multiple. There are the formal channels where we talk to government, we make submissions, we appear before...
On the other side of it is, of course, the state should not interfere with the bar. It should not certainly interfere in the way the bar is set up, the way the executive body of the Bar Council, is elected. That's a matter for the members of the bar, a matter for the bar. And you see that in every instrument. I've just shown you the universal basic principle, United Nations basic principles on the role of lawyers, almost the first document that we look to. Then you have the Montreal Declaration, which is a document that we find a manifestation of that document in many of our constitutions, certainly even in the law that governs us. And another document, the International Commission of Jurists document on the independence of the legal profession. These are there. These are tried principles. An important other aspect of the independence of the bar is there's no such thing as an independent of the bar. There's no such thing as an independent judiciary if the bar is not independent. I was recently told, what does it matter if the bar is independent or not, so long as you've got an independent judiciary? And that's a grave misunderstanding of the roles that we play, both as the lawyers within the independent bar and the judiciary within the independent judiciary. We supplement each other, we complement each other. One cannot exist without the other. And that's why it's so important, and we should never forget that the hallmark of any free democratic society is both an independent bar and an independent judiciary, not one without the other.
And so when you do that, you cannot let them go. We cannot have a confrontational conflict situation where they can conveniently turn their backs on us. I'm not saying that the present government is our enemy, but we know we have to ride or walk a tight line. We have to know when to be diplomatic, when to push, when to nudge. We cannot be on a confrontational course all the time. So that is the attitude we are taking at the moment to ensure that we put in place certain mechanisms, that we are consulted. You know, this present government has given a lot of importance to the Bar Association. We have our nominees on the Right to Information Act, which was passed recently. We have our nominees where we were to have our nominees on the Constitutional Council, which is one of the bodies which was brought in by the new government to ensure independence of the judiciary, independence of the public service, the police, the elections commissioner. But unfortunately, as I told you, because there were some members of the former government, they consider us enemies. So they did not want the bar to be influential factor in constituting the Constitutional Council. But perhaps that could change over the next few months.
And the orders had to be limited in time. They could not be indefinite. They had to be limited in time, albeit with the prospect of an extension. There had to be the opportunity for a person against whom such an order had been made to go back to the court and seek to have the order discharged if their circumstances changed. And we wanted this regime monitored by an independent monitor. We have a number of options in Australia in terms of national security legislation, and we wanted this regime monitored, and we wanted it reviewed after a period of 3 years. Now, I'm very pleased to say that the Attorney and his staff were receptive to those submissions. They were receptive to the campaign that we ran, and when it was announced, or when the policy framework was announced, each and every one of those submissions had been accepted, save we, at this stage, for the independent monitor. Now, of course, it remains to be seen as to what form the legislation will take. I mean, the devil is always in the detail, and we will await the actual legislation, the text of the legislation, before we pat ourselves too strongly on the back. But the point is that because we have a relationship with government where we are listened to, because we have access to the media, because we have an approach which is, to the greatest extent possible, cooperative rather than just a voice of protest, we are able to, and we're able to in this instance, we believe, influence the debate.
Ordinances by their nature are supposed to be temporary measures, so the Constitution provides for these checks and balances, which are basically that an ordinance can only be promulgated when both the houses of the legislature are not in session. Two, the moment the houses come into session, 6 weeks after the session commences, the ordinance ceases to exist. The words used are, ceases to operate. These are the checks and balances put into the Constitution. In practice, unfortunately, what has happened is that successive governments used the ordinance route to quickly enact things that they thought would take a long while to push through by the normal process of debate and discussion. And they started over a period of time with emergency measures, and as time passed and finding that the courts were willing to turn a blind eye to their using it for not so emergency measures, the government practically made it into an alternate route for legislation. So any legislation which was either very populist in nature, or which was expected to meet with some opposition to start with, or which was expected to go into long debates in Parliament or in the state legislatures, would be typically introduced by the ordinance route.